Start. The Supreme Court observed that for determining capital value for imposing property tax under Mumbai Municipal Corporation Act, only the present physical attributes and status of the land and building can be considered and not the future prospects of the land. The bench, comprising CJI, dismissed appeals filed by Mumbai Municipal Corporation, which held that Rules 20, 21, and 22 of the Capital Value Rules 2010 and 2016 are ultra vires the provisions of the MMC Act. Appeals filed against that part of the judgment of the High Court which upheld validity of various provisions of the MMC Act have also been dismissed. Before the Bombay High Court, the Property Owners Association and others filed writ petitions challenging the validity of computation and levy of property tax based on capital value system. The petitions also challenged the wires of Capital Value Rules 2010, the Capital Value Rules of 2015. Some of the petitions also challenged the amendment effected to the MMC Act pertaining to the implementation of the capital value system for computing and assessing property tax. The High Court rejected the challenge as to the validity of various provisions of the MMC Act, but it held Rules 20, 21, and 22 of the Capital Value Rules 2010 and 2015 to be ultra vires the provisions of the MMC Act. In appeal, the apex court bench noted Rule 20 of the Capital Value Rules of 2010 and the Capital Value Rules of 2015 empower the commissioner to consider the capability of the open land of utilizing more than one floor space index within bracket FSI or any transfer of development right within bracket TDR. The High Court, in our view, was therefore right in concluding that Rule 20 of the Capital Value Rules of 2010 and the Capital Value Rules of 2015 would be ultra vires the provisions of subsections 1A and 1B of Section 154 of the MMC Act. On the issue regarding retrospectivity of the capital value rules of 2010, the bench observed that there being no empowerment to compute and or levy property tax with retrospective effect by the statute itself, the rule making power in any view of the matter could not have created a liability pertaining to the period well before the rules came into effect. The first ground, as set out in paragraph 15 supra, was therefore rightly answered by the High Court against the corporation. Logically, the rules having come into force on 23 2012, the levy and computation of property tax on capital value would be available and possible on and with effect from 23 2012 and not with any retrospective operation.